Are you concerned about your land being taken by a government department or local council? According to the Australian Bureau of Statistics, the population in Southeast Queensland in the last 10 years grew more than double the rate of the rest of the state. During the COVID-19 pandemic, the population in regional areas within Southeast Queensland, like the Sunshine Coast, grew more than the capital cities for the first time in more than 40 years. In Queensland, the law provides that local and state governments, which are referred to as the constructing authorities for the purposes of the law, have very broad powers to take privately owned land in exchange for market value compensation. If there is a business operating from the land that they take, pursuant to a lease for example, then the lessee is also entitled to submit their claim for compensation. The resumption process is usually commenced by a constructing authority by serving a notice of intention to resume. The notice that they serve should set out the purpose for which the land is required and inform the landowner or interest holder of the rights afforded to them under the legislation. Prior to the issuing of a notice of intent, you may be eligible to submit an application for early acquisition. The criteria for this application will depend on who the constructing authority is. Although if the resumption is announced and you can demonstrate that you would suffer hardship while you're waiting for the notice to be served, then you can ask the constructing authority to acquire your land before the notice is issued. If you receive a notice of intention to resume your land, you will be provided the right to object and attend a meeting to discuss your concerns. If you wish to object, it is important you obtain legal advice to ensure the basis for your objection is properly presented. The constructing authority must give proper consideration to your objection and notify you of its decision. If your objection is unsuccessful, you can challenge the constructing authority's decision in court. If you receive the notice and do not wish to object, then the constructing authority will formally take your land, including any leases at that land, by publishing a notice in the Government Gazette. From this date, the land vests with the constructing authority, and the landowner and tenant have 3 years to submit their claim for compensation. The compensation payable will depend on a number of factors, although it is typically the market value of the land at the date it was taken. Your claim can also include other costs, so long as they are reasonably incurred and directly relate to the taking of the land. If you are the owner of a business operating from the land, pursuant to a registered lease, then compensation may be payable for the market value of the business, assuming the resumption results in the total destruction of that business. Otherwise, if you're able to relocate the business to an alternative site, you can seek compensation for the relocation costs. You will also be compensated for any valuation or legal fees required to be incurred in preparation of your claim. If you can't reach an agreement with the constructing authority on the amount of compensation payable, you can file your claim in the Land Court of Queensland to ask the court to make a decision. If you find yourself in this situation, please contact Argon Law today. We can help with preparing your claim and advocating on your behalf to ensure you achieve a fair outcome.